Question 1. Implementation of a new trade agreement between two foreign nations has led to a significant increase in the price of a key raw material used by manufacturers in Alabama. The agreement, negotiated and executed entirely outside the United States, has resulted in a cartel among foreign suppliers that artificially inflates the price of this material, directly impacting Alabama-based businesses that rely on it for their production. These Alabama businesses are now facing reduced profit margins and are considering legal action under Alabama Antitrust Law. What is the most appropriate course of action for these Alabama businesses to pursue regarding jurisdiction? Option A. File a claim in the foreign nations where the trade agreement was negotiated, abandoning any attempt to seek redress under Alabama law due to the extraterritorial nature of the conduct. Option B. Assume that because the trade agreement and cartel were formed and operate outside of Alabama, Alabama courts lack any jurisdiction to hear an antitrust claim. Option C. Assert jurisdiction based solely on the fact that Alabama businesses are experiencing economic harm, without further analysis of the directness, substantiality, or foreseeability of the anti-competitive effects within the state. Option D. Pursue a claim under the Alabama Antitrust Act, arguing that the foreign trade agreement and subsequent cartel have a direct, substantial, and foreseeable anti-competitive effect within Alabama, thereby justifying extraterritorial jurisdiction. Correct answer is D. Pursue a claim under the Alabama Antitrust Act, arguing that the foreign trade agreement and subsequent cartel have a direct, substantial, and foreseeable anti-competitive effect within Alabama, thereby justifying extraterritorial jurisdiction. Explanation. This scenario presents a professional challenge because it requires a nuanced understanding of the extraterritorial reach of Alabama antitrust laws, specifically the Alabama Antitrust Act. Determining whether Alabama courts can assert jurisdiction over a foreign entity's conduct that has a substantial effect on competition within Alabama demands careful analysis of established legal principles and the specific facts. The challenge lies in balancing Alabama's legitimate interest in protecting its markets with the principles of international comity and avoiding undue interference with foreign sovereignty. The best approach involves a thorough analysis of the Alabama Antitrust Act's provisions concerning extraterritorial application, focusing on whether the alleged conduct, though occurring outside Alabama, had a direct, substantial, and foreseeable anti-competitive effect within the state. This requires examining case law interpreting similar statutes, particularly regarding the effects test, or impact test, which is often the basis for asserting jurisdiction over foreign conduct. The Alabama Antitrust Act, like many state antitrust laws, is designed to protect competition within Alabama. When conduct outside the state demonstrably harms competition within the state, Alabama courts have a basis to assert jurisdiction. This approach prioritizes the protection of Alabama's economic interests as intended by the legislature, while still acknowledging the need for a clear nexus between the foreign conduct and the domestic harm. An incorrect approach would be to assume that because the conduct occurred entirely outside Alabama, Alabama courts automatically lack jurisdiction. This fails to recognize that antitrust laws are often designed to address anti-competitive effects, regardless of the physical location of the conduct. Such an assumption would abdicate Alabama's responsibility to protect its markets from harmful practices originating elsewhere. Another incorrect approach would be to assert jurisdiction solely based on the potential for any economic impact within Alabama, without requiring that the impact be substantial and foreseeable. This overextends the reach of the law and could lead to unwarranted assertions of jurisdiction, potentially violating principles of international law and comity. The substantial effect requirement is crucial for establishing a legitimate basis for extraterritorial jurisdiction. Finally, an incorrect approach would be to defer jurisdiction to the foreign country without a proper analysis of the Alabama Antitrust Act's extraterritorial provisions and the specific facts. While comity is important, it should not be a blanket abdication of Alabama's right to enforce its own laws when its markets are demonstrably harmed. The decision to defer should be based on a careful assessment of whether the foreign jurisdiction provides adequate remedies and whether exercising Alabama jurisdiction would unduly interfere with foreign relations. Professionals should approach such situations by first identifying the relevant state antitrust statute and its provisions on extraterritorial application. Second, they must meticulously gather facts to determine the nature and extent of the conduct and its impact within Alabama. Third, They should research relevant case law interpreting the extraterritorial reach of similar state antitrust laws, paying close attention to the effects test. Fourth, they must apply these legal standards to the specific facts, assessing whether the conduct had a direct, substantial, and foreseeable anti-competitive effect within Alabama. Finally, they should consider principles of comity and international law, but only after establishing a strong jurisdictional basis under Alabama law. Question 2. To address the challenge of assessing potential monopolistic behavior under the Alabama Competition Act, a company in the Alabama construction materials supply market has accumulated a significant market share. The Alabama Attorney General's office is reviewing whether this market share, combined with certain business practices, raises concerns about monopolization. Which of the following analytical approaches best aligns with the principles of Alabama antitrust law when evaluating the company's market share? Option A. Prioritize the company's stated intent to become the dominant supplier in the market over its actual market share and competitive landscape. Option B. Analyze the company's market share in conjunction with factors such as barriers to entry, market trends, and the nature of its business practices to determine if there is a dangerous probability of monopolization. Option C. Focus solely on whether consumers have already experienced demonstrable price increases or reduced output as the primary indicator of anti-competitive market power. Option D. Conclude that a market share exceeding 50% automatically constitutes a violation of Alabama antitrust law, regardless of other market conditions or the firm's conduct. The correct answer is B. Analyze the company's market share in conjunction with factors such as barriers to entry, market trends, and the nature of its business practices to determine if there is a dangerous probability of monopolization. Explanation. This scenario is professionally challenging because it requires a nuanced understanding of market share analysis under Alabama antitrust law, specifically the Alabama Competition Act, without relying on simplistic numerical thresholds. The challenge lies in discerning whether a significant market share, even if not explicitly defined by a rigid percentage, indicates a dangerous probability of monopolization or anti-competitive conduct. Professionals must exercise careful judgment to avoid both overzealous enforcement based on insufficient evidence and under-enforcement that allows harmful market power to develop. The best approach involves a comprehensive assessment of market share in conjunction with other relevant factors to determine if a dangerous probability of monopolization exists. This includes analyzing the nature of the market, the barriers to entry, the trend of market share over time, and the conduct of the dominant firm. Alabama antitrust law, like federal law, focuses on the actual or probable effects of market power on competition. Therefore, a market share analysis that considers these qualitative and dynamic aspects, rather than a static numerical cutoff, aligns with the law's intent to prevent anti-competitive harm. This approach is correct because it directly addresses the statutory concern of monopolization or attempted monopolization by examining the structural and behavioral indicators of market power and its potential misuse. An incorrect approach would be to solely rely on a specific market share percentage, such as 40% or 50%, as a definitive indicator of illegality. Alabama antitrust law does not prescribe such rigid numerical benchmarks for market share analysis. Using a fixed percentage without considering other factors ignores the complexity of market dynamics and can lead to erroneous conclusions. This approach fails to comply with the law's focus on the dangerous probability of monopolization, which is a fact-specific inquiry. Another incorrect approach is to dismiss a high market share simply because the firm's conduct has not yet resulted in demonstrable consumer harm. Alabama antitrust law is concerned with preventing anti-competitive conduct and the dangerous probability of monopolization, not just the accomplished fact of harm. Waiting for definitive consumer injury to occur before investigating a firm with a substantial market share could allow anti-competitive conditions to solidify, making future intervention more difficult and less effective. This approach neglects the proactive nature of antitrust enforcement. A third incorrect approach is to focus exclusively on the firm's intent to dominate the market, irrespective of its actual market share or the competitive landscape. While intent can be a factor, Alabama antitrust law, like federal law, primarily assesses the structural and economic realities of the market and the firm's position within it. Firm may have an intent to dominate, but if market conditions do not provide the power to achieve or maintain that dominance anti-competitively, or if its market share is not significant enough to pose a dangerous probability of monopolization, then the intent alone may not be sufficient for a violation. This approach misplaces the emphasis from the power to harm competition to the mere desire to do so. Professionals should employ a fact-intensive, holistic approach. This involves first defining the relevant product in geographic markets. Then, they must analyze the firm's market share within those markets, considering its magnitude, trend, and the stability of the market. Crucially, this market share analysis must be integrated with an examination of other factors, including barriers to entry, the presence of vigorous competition, the nature of the firm's conduct, and the potential for that conduct to harm competition or consumers. This comprehensive evaluation ensures that enforcement decisions are grounded in a thorough understanding of market realities and the specific requirements of Alabama antitrust law. Question 3. The review process indicates that a large, established Alabama-based agricultural cooperative has entered into an exclusive supply agreement with a single distributor for all of its produce sold within the state. This distributor, in turn, has agreements with most of the major grocery retailers in Alabama, effectively limiting the ability of other distributors to source produce from the cooperative and potentially limiting the ability of other producers to supply the retailers. Considering the historical context of antitrust law in Alabama, particularly the application of the Sherman Act's principles to agricultural markets, which of the following analytical frameworks best addresses whether this exclusive supply agreement violates Alabama antitrust law? Option A. Presume the exclusive supply agreement is illegal per se because it involves an agreement between a supplier and a distributor that restricts competition, without further inquiry into market conditions or the agreement's actual or probable effects. Option B. Apply a generalized economic theory of vertical integration to determine the legality of the agreement, without specific reference to Alabama's antitrust statutes or established case law regarding exclusive dealing arrangements in agricultural markets. Option C. Analyze the agreement under the rule of reason, assessing its potential anti-competitive effects on competition within the relevant Alabama agricultural markets, considering factors such as market definition, the cooperatives and distributors' market shares, barriers to entry for other distributors and producers, and the overall impact on consumer choice and prices. Option D. Focus solely on the size and market dominance of the agricultural cooperative, concluding that any exclusive arrangement it enters into is inherently anti-competitive and thus illegal under Alabama antitrust law, irrespective of the agreement's specific terms or market impact. The correct answer is C. Analyze the agreement under the rule of reason, assessing its potential anti-competitive effects on competition within the relevant Alabama agricultural markets, considering factors such as market definition, the cooperatives and distributors' market shares, barriers to entry for other distributors and producers, and the overall impact on consumer choice and prices. Explanation. The review process indicates a scenario that is professionally challenging due to the need to balance the historical intent of antitrust legislation with the evolving economic landscape of Alabama. Understanding the foundational principles of the Sherman Act, as adopted and interpreted within Alabama's legal framework, is crucial for discerning whether a particular business practice constitutes an illegal restraint of trade or a legitimate competitive strategy. The challenge lies in applying these historical principles to contemporary business models and market dynamics, without succumbing to anachronistic interpretations or overlooking subtle but significant shifts in market power and consumer impact. The correct approach involves a thorough examination of the business practice in question through the lens of established Alabama antitrust jurisprudence, focusing on whether it has the actual or probable effect of substantially lessening competition or creating a monopoly within Alabama markets. This requires an analysis of market definition, market share, barriers to entry, and the nature of the alleged restraint. Specifically, it necessitates understanding how Alabama courts have historically interpreted Section 1 and Section 2 of the Sherman Act as applied within the state, and whether the practice aligns with established per se violations or requires a rule of reason analysis. The justification for this approach is rooted in the principle of legal precedent and the statutory framework of Alabama antitrust law, which aims to protect competition and consumers from anti-competitive conduct. Adherence to established legal tests ensures predictability and fairness in antitrust enforcement. An incorrect approach would be to solely focus on the size of the companies involved without analyzing their market power or the impact of their conduct on competition within Alabama. This fails to recognize that antitrust law is concerned with the effects of conduct on the market, not merely the size of the participants. Another incorrect approach would be to assume that any agreement between competitors, regardless of its effect, is inherently illegal. This overlooks the nuances of the rule of reason, which permits certain agreements if their pro-competitive benefits outweigh their anti-competitive harms. Finally, an approach that relies on generalized economic theories without grounding them in Alabama's specific legal interpretations of antitrust principles would be flawed, as it might lead to conclusions inconsistent with state law and precedent. The professional reasoning process for similar situations should involve a multi-step analysis. First, identifying the relevant market, S within Alabama. Second, assessing the market power of the firms involved. Third, characterizing the business practice and determining whether it constitutes a per se violation or requires a rule of reason analysis. And fourth, applying the appropriate legal test, considering established Alabama case law and statutory provision to evaluate the practice's impact on competition and consumers. Question 4. Examination of the data shows that Apex Solutions, a company holding a significant market share in the Alabama software development sector, has recently implemented a strategy involving deep discounts on its core products and exclusive long-term contracts with major clients. Competitors allege that these actions are designed to drive them out of the market and stifle innovation. Considering the Alabama Antitrust Act, which of the following represents the most appropriate initial response for an investigator tasked with assessing the legality of Apex Solutions' conduct? Option A. Accept Apex Solutions' assertion that its actions are purely a result of aggressive but legitimate competition, and focus solely on whether consumers have experienced immediate price increases as a direct consequence. Option B. Conclude that Apex Solutions' market dominance and aggressive business practices are simply indicative of successful competition, and therefore no further investigation into potential antitrust violations is warranted under Alabama law. Option C. Immediately initiate legal proceedings against Apex Solutions based on its substantial market share, assuming that such dominance inherently implies illegal monopolization under the Alabama Antitrust Act. Option D. Conduct a detailed analysis of Apex Solutions' pricing strategies and contract terms to determine if they constitute predatory pricing or exclusionary practices aimed at substantially lessening competition in the Alabama market, while also assessing whether Apex Solutions has engaged in conduct that demonstrates an intent to monopolize. The correct answer is D. Conduct a detailed analysis of Apex Solutions' pricing strategies and contract terms to determine if they constitute predatory pricing or exclusionary practices aimed at substantially lessening competition in the Alabama market, while also assessing whether Apex Solutions has engaged in conduct that demonstrates an intent to monopolize. Explanation. This scenario presents a professional challenge because it requires understanding the nuances of Alabama antitrust law, specifically the Alabama Antitrust Act, and how it applies to competitive practices that might appear beneficial on the surface but could stifle competition. The core issue is whether a dominant firm's actions are predatory or designed to maintain an illegal monopoly, rather than simply being a result of superior business acumen. Careful judgment is required to distinguish between legitimate competition and anti-competitive conduct that violates Alabama law. The correct approach involves a thorough investigation into the alleged conduct, focusing on whether the actions of the dominant firm, Apex Solutions, are specifically designed to harm competitors and reduce overall market competition in Alabama, rather than simply outcompeting them through innovation or efficiency. This requires examining Apex Solutions' pricing strategies, exclusive dealing arrangements, and any potential predatory intent. The Alabama Antitrust Act prohibits monopolization and attempts to monopolize, as well as agreements that restrain trade. Therefore, a proper response must assess whether Apex Solutions' conduct falls into these prohibited categories. This approach is correct because it directly addresses the elements of an antitrust violation under Alabama law by seeking evidence of anti-competitive intent and effect, rather than making assumptions based on market share alone. An incorrect approach would be to assume that Apex Solutions' market dominance automatically signifies illegal monopolization. While market share is a factor, it is not determinative. Alabama antitrust law, like federal law, recognizes that monopolies can arise from legitimate business success. Simply being the largest player does not, in itself, violate the law. This approach fails because it ignores the requirement to prove anti-competitive conduct or intent. Another incorrect approach would be to dismiss the allegations solely because Apex Solutions claims its actions are merely the result of aggressive but legitimate competition. While aggressive competition is permissible, it becomes illegal when it crosses the line into predatory practices designed to eliminate rivals and harm consumers. This approach is flawed because it accepts the company's self-serving justification without independent verification and fails to consider the potential for such justifications to mask anti-competitive behavior. A final incorrect approach would be to focus only on whether Apex Solutions' actions have directly harmed consumers through higher prices. While consumer harm is a key element in many antitrust cases, the Alabama Antitrust Act also prohibits conduct that unreasonably restrains trade or creates a monopoly, even if immediate consumer price increases are not apparent. The focus must be on the impact on the competitive process itself. This approach is incorrect because it narrows the scope of potential violations beyond what is contemplated by the Act, which aims to protect competition as well as consumers. Professionals should employ a decision-making framework that begins with a neutral and objective assessment of all available facts and evidence. This involves understanding the specific provisions of the Alabama Antitrust Act, identifying the relevant market, analyzing the conduct in question for evidence of anti-competitive intent or effect, and considering the potential impact on competition and consumers. When faced with allegations of anti-competitive behavior, it is crucial to avoid making assumptions and to conduct a thorough, evidence-based investigation that aligns with the legal standards set forth in the applicable state law. Question 5. Upon reviewing the market dynamics in Alabama's telecommunications sector, a dominant provider, ConnectAll, has recently implemented a significant price reduction on its high-speed internet services in specific geographic areas where smaller, independent competitors are also operating. These competitors have reported substantial revenue losses and are struggling to maintain their operations. ConnectAll argues that this is simply a competitive response to market demand and their own cost efficiencies. An investigation is being considered under Alabama antitrust law, which mirrors federal Sherman Act principles. Which of the following investigative approaches best aligns with the principles of antitrust enforcement in this context? Option A. Conduct a detailed analysis of ConnectAll's cost structure to determine if the pricing is below its average variable cost, and assess the duration and intent behind the price reduction to ascertain if it is a predatory practice aimed at eliminating competition. Option B. Advise the smaller competitors to cease operations in the affected areas to avoid further financial losses, as ConnectAll's pricing strategy is a natural consequence of market forces. Option C. Immediately initiate legal proceedings against ConnectAll based on the reported financial distress of its competitors, as this indicates a clear harm to the market. Option D. Focus the investigation solely on ConnectAll's market share, concluding that its dominance inherently makes any aggressive pricing strategy an illegal restraint of trade. The correct answer is A. Conduct a detailed analysis of ConnectAll's cost structure to determine if the pricing is below its average variable cost, and assess the duration and intent behind the price reduction to ascertain if it is a predatory practice aimed at eliminating competition. Explanation. This scenario presents a professional challenge due to the potential for a large, established company to leverage its market dominance in a way that stifles competition, potentially violating Alabama antitrust law, which is largely informed by federal antitrust principles like the Sherman Act. The core issue is discerning whether the company's actions constitute legitimate competition or an illegal restraint of trade. Careful judgment is required to analyze the intent and effect of the company's pricing strategy. The best professional approach involves a thorough investigation into the economic realities of the market and the company's conduct. This includes gathering evidence to determine if the pricing strategy is predatory, meaning it is set below cost with the intent to drive competitors out of business, or if it is a legitimate response to market conditions, or a desire to gain market share through superior efficiency or innovation. Analyzing the company's cost structure, the duration and consistency of the low pricing, and the impact on competitors' ability to survive and compete are crucial. If the evidence points to pricing below cost with the intent to eliminate competition, this aligns with the prohibition against monopolization and attempts to monopolize under Section 2 of the Sherman Act, as interpreted and applied within Alabama's legal framework. An incorrect approach would be to immediately conclude that any aggressive pricing by a dominant firm is illegal. This fails to recognize that competition often involves price reductions and that the Sherman Act is designed to protect competition, not individual competitors. Another incorrect approach is to focus solely on the fact that competitors are suffering financial losses. While this is an effect of the pricing, it does not, in itself, prove an antitrust violation. The law requires proof of predatory intent or conduct that unreasonably restrains trade. Simply observing that the dominant firm is larger and has more resources, and therefore can afford to lower prices, is not sufficient grounds for an antitrust claim. Professionals should approach such situations by adopting a fact-based, analytical framework. This involves understanding the relevant market, identifying the alleged anti-competitive conduct, and assessing its impact on competition. The focus should always be on whether the conduct harms the competitive process itself, rather than merely harming a specific competitor. This requires a nuanced understanding of economic principles and antitrust law, distinguishing between vigorous competition and illegal monopolistic practices. Question 6. When evaluating a proposed merger between two Alabama-based companies that are significant competitors in the state's retail grocery market, what is the most appropriate course of action under the Clayton Act to determine if the merger poses a threat to competition within Alabama? Option A. Conclude that the merger is unlikely to violate the Clayton Act because both companies operate solely within Alabama and are not national entities. Option B. Prioritize the potential for cost savings and operational efficiencies for the merged entity, assuming these benefits will ultimately be passed on to Alabama consumers. Option C. Conduct a comprehensive analysis of the merger's potential to substantially lessen competition or tend to create a monopoly within the relevant geographic and product markets in Alabama, considering market concentration, barriers to entry, and the likelihood of anti-competitive conduct. Option D. Rely on the absence of any formal complaints from competitors or consumers within Alabama as sufficient evidence that the merger will not harm competition. The correct answer is C. Conduct a comprehensive analysis of the merger's potential to substantially lessen competition or tend to create a monopoly within the relevant geographic and product markets in Alabama, considering market concentration, barriers to entry, and the likelihood of anti-competitive conduct. Explanation. This scenario presents a professional challenge because it requires a nuanced understanding of the Clayton Act's provisions regarding mergers and acquisitions, specifically concerning potential anti-competitive effects. The challenge lies in distinguishing between legitimate business consolidation that may lead to efficiencies and a merger that substantially lessens competition or tends to create a monopoly within Alabama. Careful judgment is required to assess the market dynamics, the parties' market power, and the potential impact on consumers and other businesses in Alabama. The best approach involves a thorough analysis of the proposed merger's potential impact on competition within Alabama, considering factors such as market concentration, barriers to entry, and the likelihood of coordinated or unilateral anti-competitive conduct. This approach aligns with the Clayton Act Section 7, which prohibits mergers where the effect may be substantially to lessen competition or to tend to create a monopoly in any line of commerce in any section of the country. Specifically, in the context of Alabama, this means evaluating the impact on the relevant geographic and product markets within the state. This requires gathering extensive data on market shares, pricing, and consumer behavior within Alabama to determine if the merger would create undue market power for the combined entity, leading to higher prices, reduced output, or diminished innovation for Alabama consumers and businesses. An approach that focuses solely on the potential for cost savings and operational efficiencies without a corresponding rigorous analysis of competitive effects is professionally unacceptable. This fails to address the core concern of the Clayton Act, which is the protection of competition. Such an approach would overlook the possibility that efficiencies might be achieved through anti-competitive means, or that the claimed deficiencies might not materialize or be passed on to consumers. Another professionally unacceptable approach is to dismiss concerns based on the fact that both companies operate primarily within Alabama and are not national players. The Clayton Act applies to mergers that affect competition within any section of the country, and a significant market within a single state like Alabama can constitute such a section. Ignoring the potential for substantial lessening of competition within Alabama simply because the companies are not interstate giants is a misinterpretation of the law. Finally, an approach that relies on the absence of explicit complaints from competitors or consumers as a sole indicator of no anti-competitive harm is also flawed. The Clayton Act is a preventative measure. The government has the authority to challenge mergers based on the potential for anti-competitive effects, even if no harm has yet manifested or been formally reported. Waiting for complaints can mean waiting until significant damage to competition has already occurred, making remedies more difficult. The professional decision-making process for similar situations should involve a proactive and comprehensive assessment of potential anti-competitive impacts. This includes 1. Defining the relevant product and geographic markets within Alabama. 2. Calculating market concentration, e.g., using the Herfindahl-Hirschman Index and assessing changes due to the merger. 3. Evaluating barriers to entry for new competitors in the Alabama market. 4. Analyzing the likelihood of coordinated or unilateral anti-competitive behavior by the merged firm. 5. Considering any potential pro-competitive justifications and whether they outweigh the anti-competitive risks. 6. Consulting with legal counsel specializing in antitrust law in Alabama to ensure compliance with state and federal regulations. Question 7. The analysis reveals that a large retail chain operating extensively throughout Alabama has implemented a new pricing strategy for essential household goods. This strategy involves offering significantly below-cost prices on a select range of popular items, while simultaneously increasing prices on less frequently purchased, but equally essential, goods. Competitors in Alabama have complained that this practice is designed to drive them out of business, thereby allowing the chain to eventually raise prices across the board once competition is diminished. Under the Federal Trade Commission Act, as applied to Alabama's business environment, which of the following represents the most appropriate initial response for the Alabama Attorney General's office to investigate these allegations? Option A. Initiate a comprehensive investigation into the pricing strategy, focusing on defining the relevant product and geographic markets in Alabama, assessing the retail chain's market power, and evaluating the actual or probable anti-competitive effects of the pricing strategy on competition and consumers within Alabama. Option B. Advise the retail chain that as long as they are not engaging in explicit price-fixing agreements with other retailers, their pricing strategies are permissible under federal and state antitrust laws. Option C. Focus the investigation solely on whether the retail chain's actions are intended to harm its competitors, without considering the broader impact on market competition or consumer welfare in Alabama. Option D. Immediately issue a cease and desist order against the retail chain, demanding an end to the below-cost pricing strategy based on the competitor's complaints alone. The correct answer is A. Initiate a comprehensive investigation into the pricing strategy, focusing on defining the relevant product and geographic markets in Alabama, assessing the retail chain's market power, and evaluating the actual or probable anti-competitive effects of the pricing strategy on competition and consumers within Alabama. Explanation. The analysis reveals a scenario that is professionally challenging due to the potential for a company to engage in practices that, while seemingly beneficial for market share, could violate antitrust principles under the Federal Trade Commission Act, FTC Act, as interpreted by Alabama law. The core challenge lies in distinguishing between legitimate competitive strategies and anti-competitive conduct that harms consumers. Careful judgment is required to assess the intent and impact of such actions. The best professional approach involves a thorough investigation into the alleged conduct, focusing on whether it has the effect of substantially lessening competition or tending to create a monopoly in the relevant market within Alabama. This requires gathering evidence on market definition, market power, the nature of the alleged exclusionary conduct, and its impact on consumers, such as higher prices, reduced output, or diminished quality. This approach aligns with the FTC Act's broad prohibition against unfair methods of competition and unfair or deceptive acts or practices, as enforced by Alabama courts and regulatory bodies. The focus is on the actual or probable anti-competitive effects, rather than mere intent. An incorrect approach would be to dismiss the allegations solely because the company's actions are intended to increase its market share. A market share growth is a natural outcome of successful competition. The FTC Act is concerned with the means used to achieve that growth and their impact on the competitive landscape. Another incorrect approach would be to assume that because the company is a dominant player, its actions are automatically illegal. Dominance itself is not illegal. It is the abuse of that dominance to stifle competition that is prohibited. Finally, an approach that relies only on the absence of explicit price fixing or market allocation agreements would be insufficient. The FTC Act covers a wide range of exclusionary practices that may not fit neatly into traditional cartel definitions, but still harm competition. Professionals should employ a decision-making framework that begins with understanding the specific allegations and the relevant market. This involves identifying the applicable legal standards under the FTC Act and Alabama antitrust jurisprudence. Evidence gathering should be comprehensive, considering both direct and circumstantial evidence of anti-competitive intent and effect. Legal counsel should be consulted to interpret the nuances of antitrust law and guide the investigation. The ultimate determination should be based on a balanced assessment of the conduct's impact on competition and consumer welfare within Alabama. Question 8. Comparative studies suggest that businesses often seek to maximize profits through various strategic initiatives. A large retail chain operating exclusively within Alabama is considering implementing a new pricing strategy for a popular product. This strategy involves significantly lowering prices on this product in certain geographic areas within Alabama, where it faces intense competition, with the stated goal of driving smaller, local competitors out of business. The company's internal legal department has raised concerns that this aggressive pricing might be viewed as an attempt to monopolize or engage in predatory pricing, potentially violating Alabama antitrust law. The company's CEO, however, argues that this is simply smart business and aggressive competition, and that as long as they are not explicitly colluding with other retailers, their actions are legal. Which of the following approaches best addresses the company's concerns and ensures compliance with Alabama antitrust law? Option A. Conduct a detailed legal analysis of the proposed pricing strategy under the Alabama antitrust law, assessing whether it constitutes an unreasonable restraint of trade or an attempt to monopolize, considering factors such as market power, intent, and the impact on competition within Alabama. Option B. Implement the pricing strategy in targeted areas, but only after obtaining assurances from the company's largest competitor in Alabama that they will not engage in a similar pricing war, thereby avoiding direct conflict. Option C. Rely on general principles of competitive pricing and market share acquisition, as understood from national business practices, and assume these principles are applicable and sufficient to ensure compliance with Alabama antitrust law. Option D. Proceed with the pricing strategy as planned, assuming that aggressive competition and the absence of explicit agreements with competitors insulate the company from any antitrust liability under Alabama law. The correct answer is A. Conduct a detailed legal analysis of the proposed pricing strategy under the Alabama antitrust law, assessing whether it constitutes an unreasonable restraint of trade or an attempt to monopolize, considering factors such as market power, intent, and the impact on competition within Alabama. Explanation. Scenario analysis. This scenario presents a professional challenge due to the potential for a business to engage in conduct that, while seemingly beneficial to its immediate profitability, could violate Alabama antitrust law. The core challenge lies in distinguishing between legitimate competitive practices and those that unlawfully restrain trade or create a monopoly. A careful judgment is required to assess the intent and effect of the proposed pricing strategy on the relevant market in Alabama. Correct approach analysis. The best professional practice involves a thorough legal analysis of the proposed pricing strategy under the Alabama antitrust law. This approach correctly recognizes that the Alabama antitrust law, like many state antitrust statutes, prohibits agreements or actions that unreasonably restrain trade. Specifically, it would involve evaluating whether the proposed price-fixing arrangement constitutes a per se violation or requires a rule of reason analysis. A per se violation, such as explicit price fixing among competitors, is automatically deemed illegal. if it's not a per se violation. The analysis would then consider the pro-competitive justifications, the market power of the parties involved, the extent of the alleged restraint, and the potential for harm to competition within Alabama. This approach prioritizes compliance with the specific prohibitions and analytical frameworks established by Alabama's antitrust statutes and relevant case law. Incorrect approach is analysis. One incorrect approach involves proceeding with the pricing strategy based solely on the belief that it will increase market share and profitability, without considering its potential impact on competition or its legality under Alabama law. It fails to acknowledge the fundamental purpose of antitrust laws, which is to protect competition, not necessarily individual firms' profits. Another incorrect approach is to assume that because the conduct is internal to the company and doesn't involve explicit agreements with competitors, it is automatically legal. This overlooks potential violations related to predatory pricing or monopolization, which can be pursued under Alabama's antitrust framework even without direct collusion. Finally, relying on general business principles or practices from other states without verifying their compatibility with Alabama antitrust law is a significant regulatory failure. Alabama's specific statutory language and judicial interpretations govern antitrust matters within the state, and generic assumptions can lead to serious legal repercussions. Professional reasoning. Professionals facing such a situation should adopt a proactive and compliance-oriented decision-making process. This involves 1. Identifying potential antitrust risks associated with proposed business strategies. 2. Consulting with legal counsel specializing in Alabama antitrust law to obtain a precise interpretation of relevant statutes and case law. 3. Conducting a thorough market analysis to understand the competitive landscape and the potential impact of the proposed actions. 4. Documenting the analysis and the rationale for any business decisions made, particularly those that could be construed as anti-competitive. 5. Prioritizing adherence to the specific legal framework of Alabama over assumptions or practices from other jurisdictions. Question 9. The investigation demonstrates that a cartel of foreign manufacturers, none of whom are headquartered in Alabama, has allegedly engaged in price-fixing activities for a specific component used in consumer electronics. While the cartel's meetings and agreements occurred entirely outside the United States, evidence suggests that the inflated prices resulting from this cartel have been passed on to consumers in Alabama, leading to demonstrably higher prices for electronic goods purchased by Alabama residents. The Alabama Attorney General's office is considering whether to initiate an antitrust investigation and potential enforcement action. Which of the following represents the most appropriate initial course of action for the Alabama Attorney General's office? Option A. Conduct a preliminary investigation to determine if the alleged price fixing has a direct, substantial, and reasonably foreseeable anti-competitive effect on commerce within Alabama, focusing on the impact on Alabama consumers and businesses. Option B. Immediately initiate a full-scale investigation and file a lawsuit against the foreign manufacturers, asserting extraterritorial jurisdiction based on the presence of the affected goods in Alabama. Option C. Consult with federal antitrust authorities to determine if the matter falls exclusively under federal jurisdiction, without independently assessing Alabama's jurisdictional basis. Option D. Dismiss the matter without further inquiry, as the cartel's activities and formation occurred outside of Alabama and involved foreign entities. The correct answer is A. Conduct a preliminary investigation to determine if the alleged price fixing has a direct, substantial, and reasonably foreseeable anti-competitive effect on commerce within Alabama, focusing on the impact on Alabama consumers and businesses. Explanation. This scenario presents a professional challenge due to the potential extraterritorial reach of Alabama antitrust law and the complexities of applying domestic competition principles to international business conduct. Determining the appropriate course of action requires careful judgment to balance the protection of Alabama's commerce with respect for international sovereignty and established legal principles governing cross-border activities. The correct approach involves a thorough investigation into whether the alleged conduct has a direct, substantial, and reasonably foreseeable effect on competition within Alabama. This requires analyzing the nature of the agreement, the market share of the parties involved in Alabama, and the demonstrable impact on Alabama consumers or businesses. Alabama antitrust law, like federal antitrust law, generally requires a nexus to interstate commerce. Therefore, focusing on the direct and substantial impact within Alabama is paramount. This aligns with the principle that state antitrust laws are primarily intended to protect the economic interests of the state and its residents. An incorrect approach would be to immediately assume jurisdiction and initiate enforcement actions based solely on the fact that one of the companies has a presence in Alabama, without first establishing the requisite direct and substantial effect on Alabama commerce. This fails to acknowledge the jurisdictional limitations and could lead to an overreach of state authority, potentially violating principles of comity and international law. Another incorrect approach would be to dismiss the matter entirely because the agreement was formed outside of Alabama and involves foreign entities, without conducting any analysis of the impact within Alabama. This ignores the possibility that international conduct can indeed have anti-competitive effects within the state, provided the necessary nexus is established. A further incorrect approach would be to rely on general principles of international competition law, without specifically grounding the analysis in the framework of Alabama antitrust statutes. While international considerations are relevant, the ultimate determination of jurisdiction and potential violation must be made under the specific provisions and interpretive case law of Alabama's antitrust laws. Professionals should employ a decision-making framework that begins with a clear understanding of the jurisdictional predicates of Alabama antitrust law. This involves assessing the nexus between the alleged conduct and Alabama commerce. If a sufficient nexus appears to exist, the next step is to conduct a fact-intensive investigation to gather evidence of the direct, substantial, and reasonably foreseeable effects on competition within Alabama. This process should also consider principles of comity and the potential for conflicts with foreign law, but the primary focus must remain on establishing jurisdiction under Alabama's own legal framework. Question 10. Analysis of the following scenario under Alabama antitrust law. Apex Corp., a dominant provider of specialized industrial lubricants in the state of Alabama, holds an estimated 70% of the market share. A new competitor, Lubritech, has recently entered the market, capturing approximately 10% of the market share. Apex Corp. Has subsequently engaged in aggressive pricing strategies and exclusive dealing contracts with major industrial clients, leading to a significant decrease in Lubritech's projected sales growth. If Apex Corp's total revenue from industrial lubricants in Alabama for the past year was $50 million, and Lubritech's was $10 million, and assuming the relevant product market is specialized industrial lubricants and the geographic market is the state of Alabama, calculate the Herfindahl-Hirschman Index, HHI, for the market before Lubritech's entry and after its entry, and determine if the market concentration levels suggest a need for further antitrust scrutiny under Alabama law. Option A. Before Lubritech's entry, the HHI was approximately 7,000. After Lubritech's entry, assuming Apex Corp's share remains 70% and Lubritech's is 10%, the HHI is approximately 7,000. The market is extremely concentrated, but the lack of change indicates no anti-competitive impact from the new entrant. Option B. Before Lubritech's entry, the HHI was approximately 4,900. After Lubritech's entry, assuming Apex Corp's share remains 70% and Lubritech's is 10%, the HHI is approximately 4,900. The market is highly concentrated, but the new entrant has not significantly altered the concentration level. Option C. Before Lubritech's entry, the HHI was approximately 4,900. After Lubritech's entry, assuming Apex Corp's share remains 70% and Lubritech's is 10%, the HHI is approximately 5,000. Both levels indicate a highly concentrated market, warranting further scrutiny. Option D. Before Lubritech's entry, the HHI was approximately 4,900. After Lubritech's entry, assuming Apex Corp's share remains 70% and Lubritech's is 10%, the HHI is approximately 4,920. The market is highly concentrated, but the increase is minimal, suggesting no significant change in competitive dynamics. The correct answer is C. Before Lubritech's entry, the HHI was approximately 4,900. After Lubritech's entry, assuming Apex Corp's share remains 70% and Lubritech's is 10%, the HHI is approximately 5,000. Both levels indicate a highly concentrated market, warranting further scrutiny. Explanation. Scenario analysis. This scenario presents a professional challenge in applying Alabama antitrust law to a complex market structure. The core difficulty lies in accurately assessing market power and potential anti-competitive effects when faced with a dominant firm and a new entrant, requiring a quantitative approach to market definition and concentration measurement. Misinterpreting market share or failing to account for relevant market characteristics could lead to incorrect conclusions about the legality of the dominant firm's actions, potentially resulting in regulatory penalties or missed opportunities to address genuine competitive harms. Correct approach analysis. The best professional practice involves a rigorous quantitative analysis of market concentration using the Herfindahl-Hirschman Index, HHI. This approach correctly identifies the relevant product and geographic markets, calculates the market shares of all significant competitors within those markets, and then applies the HHI formula. The HHI provides a standardized measure of market concentration, allowing for a direct comparison against established thresholds under Alabama antitrust guidelines. Specifically, a post-merger HHI below 1,500 generally indicates an unconcentrated market. Between 1,500 and 2,500 suggests a moderately concentrated market, and above 2,500 signifies a highly concentrated market. Changes in HHI are also critical. An increase of over 100 points in a moderately concentrated market, or over 50 points in a highly concentrated market, warrants further scrutiny. This quantitative method aligns with the analytical framework typically employed by antitrust authorities in Alabama to assess potential monopolization or anti-competitive mergers. Incorrect approaches analysis. One incorrect approach would be to rely solely on the absolute market share of the dominant firm without considering the overall market structure or the impact of the new entrant's presence. This fails to acknowledge that market share alone does not definitively prove market power or anti-competitive conduct. Alabama antitrust law, like federal law, focuses on the competitive effects within a defined market, not just the size of a single entity. Another flawed approach would be to dismiss the situation as a natural outcome of competition without any quantitative assessment. This overlooks the possibility that the dominant firm's actions, such as predatory pricing or exclusionary practices, could be stifling competition and harming consumers, which is precisely what Alabama antitrust law aims to prevent. A qualitative assessment alone is insufficient when market power is potentially being abused. A third incorrect approach would be to focus only on the revenue generated by the dominant firm without defining the relevant market. Revenue is a measure of sales, not necessarily market power. Without defining the product and geographic scope of the market, it is impossible to accurately determine the firm's market share and its competitive significance within that market, rendering any analysis incomplete and potentially misleading under Alabama antitrust principles. Professional reasoning. Professionals should adopt a systematic, data-driven approach. This begins with clearly defining the relevant product and geographic markets. Subsequently, all significant market participants' market shares must be meticulously calculated. The HHI should then be computed for the pre- and post-transaction or conduct scenarios. This quantitative analysis should be supplemented by a qualitative assessment of factors such as barriers to entry, the nature of the product, and the potential for collusion or coordinated behavior. This comprehensive methodology ensures that conclusions are grounded in established antitrust principles and are defensible under Alabama law. Question 11. Consider a scenario in Alabama where Southern Steelworks, a dominant manufacturer of structural steel beams, has recently acquired a smaller competitor, Dixie Fabricators. Following the acquisition, Southern Steelworks has implemented a new pricing strategy that offers significant discounts to construction companies that agree to purchase all their structural steel beam needs exclusively from Southern Steelworks for a period of 5 years. Several smaller steel fabricators in Alabama have complained that this practice makes it difficult for them to compete, as they cannot secure the volume of business necessary to achieve similar economies of scale. Based on Alabama antitrust law, which of the following analyses best addresses whether Southern Steelworks' actions are likely to be deemed anti-competitive? Option A. Analyze the relevant market for structural steel beams in Alabama. Assess Southern Steelworks' market power within that market post-acquisition, and evaluate whether the exclusive purchasing agreements substantially lessen competition or tend to create a monopoly by foreclosing competitors from a significant portion of the market. Option B. Conclude that Southern Steelworks' acquisition of Dixie Fabricators combined with its dominant market position, automatically constitutes an illegal monopolization under Alabama antitrust law, regardless of the specific impact on competition. Option C. Determine that the pricing strategy is a legitimate business practice because Southern Steelworks is offering discounts, which generally benefit consumers, and therefore no further antitrust analysis is required. Option D. Focus solely on Southern Steelworks' intent to gain a competitive advantage, and assume that any action taken by a dominant firm to increase its market share is inherently anti-competitive. The correct answer is A. Analyze the relevant market for structural steel beams in Alabama. Assess Southern Steelworks' market power within that market post-acquisition, and evaluate whether the exclusive purchasing agreements substantially lessen competition or tend to create a monopoly by foreclosing competitors from a significant portion of the market. Explanation. This scenario presents a professional challenge because it requires a nuanced understanding of market structures under Alabama antitrust law, specifically the Alabama Competition Act. The challenge lies in distinguishing between legitimate business practices that may lead to market concentration and anti-competitive conduct that violates the law. Careful judgment is required to assess whether a firm's actions are aimed at enhancing efficiency and consumer welfare, or at unlawfully excluding competitors and harming competition. Best professional approach involves a thorough analysis of the market definition, the firm's market power within that defined market, and the nature of its business practices. This approach correctly identifies that market structure analysis is a prerequisite to determining whether specific conduct is anti-competitive. Under Alabama antitrust law, the focus is on the actual or probable effect on competition. Therefore, understanding the degree of market concentration, the number of competitors, barriers to entry, and the nature of the product or service is crucial. If the firm's actions, regardless of its market share, do not substantially lessen competition or tend to create a monopoly, they are likely permissible. This aligns with the principle that market power alone is not illegal. It is the abuse of that power that triggers antitrust scrutiny. An incorrect approach would be to assume that any firm with a significant market share is automatically engaging in illegal activity. This fails to recognize that market share is a component of market power, not a direct indicator of illegality. Alabama antitrust law requires proof of anti-competitive effects or intent, not just a large market share. Another incorrect approach is to focus solely on the firm's intent without considering the actual or probable impact on competition. While intent can be a factor, the law primarily concerns the outcome of the conduct. Third incorrect approach is to ignore the specific market in which the firm operates and make broad generalizations about market structures. Alabama antitrust law is applied to specific markets, and the competitive landscape can vary significantly from one market to another. Professionals should employ a structured decision-making process that begins with defining the relevant market. This involves identifying the product or service market and the geographic market. Next, they should assess the firm's market power within that defined market by considering factors such as market share, the number and strength of competitors, and barriers to entry. Finally, they must evaluate the firm's conduct in light of its potential or actual impact on competition, considering whether it harms consumers through higher prices, reduced output, or diminished innovation. This systematic approach ensures that conclusions are grounded in the specific facts of the case and the principles of Alabama antitrust law. Question 12. During the evaluation of the Alabama poultry farming industry, a team of antitrust analysts is tasked with determining if the market structure closely approximates perfect competition. They have gathered data indicating a large number of independent family farms operating within the state, producing a standardized broiler chicken product. The analysts are also aware that new farms can be established with moderate capital investment, and that market prices for live broilers are publicly available through industry publications. Considering these factors, which of the following assessments most accurately reflects the conditions for perfect competition in this Alabama market? Option A. The market closely approximates perfect competition because there are numerous independent sellers, a homogeneous product, relatively low barriers to entry, and readily available market price information, suggesting producers are likely price takers. Option B. The market is not perfectly competitive because some farms may have slightly different feed conversion ratios or genetic strains, meaning the product is not perfectly homogeneous. Option C. The market deviates from perfect competition because the price of broilers fluctuates daily, indicating a lack of stable pricing that would be expected in a perfectly competitive environment. Option D. The market deviates from perfect competition because the presence of a few large poultry processing companies on the buyer side suggests potential buyer power that could influence prices paid to farmers. The correct answer is A. The market closely approximates perfect competition because there are numerous independent sellers, a homogeneous product, relatively low barriers to entry, and readily available market price information, suggesting producers are likely price takers. Explanation: scenario analysis. This scenario presents a professional challenge because it requires an understanding of the theoretical underpinnings of perfect competition and how to apply those principles to a real-world market situation in Alabama. The challenge lies in distinguishing between a market that closely approximates perfect competition and one that deviates significantly, which has implications for antitrust analysis under Alabama law. Careful judgment is required to avoid mischaracterizing market structures, which could lead to incorrect antitrust enforcement decisions. Correct approach analysis. The best professional approach involves a thorough examination of the defining characteristics of perfect competition as they manifest in the Alabama poultry market. This includes assessing the number of buyers and sellers, the homogeneity of the product, chickens, the ease of entry and exit for producers, and the availability of perfect information to all market participants. If these conditions are substantially met, then the market can be considered to closely approximate perfect competition, and the poultry producers would likely be acting as price takers, with no single producer having significant market power to influence prices. This aligns with the principles of Alabama Antitrust Law, which seeks to prevent monopolistic practices and promote fair competition. The absence of significant barriers to entry and the presence of numerous, small, independent producers selling a standardized product are key indicators that the market is functioning competitively. Incorrect approaches analysis. One incorrect approach would be to focus solely on the number of producers without considering other essential elements of perfect competition. While a large number of producers is a characteristic, it is not sufficient on its own. If there are significant product differentiation, substantial barriers to entry, e.g., high capital costs for processing plants, exclusive contracts with distributors, or imperfect information regarding market prices and costs, then the market deviates from perfect competition, and producers might possess market power. This approach fails to conduct a comprehensive market structure analysis as required by antitrust principles. Another incorrect approach would be to assume that because the product is a commodity, poultry, the market must be perfectly competitive. While commodity markets often exhibit characteristics of perfect competition, this assumption overlooks potential market imperfections. For instance, if a few large processing companies dominate the buyer side of the market, they could exert monopsony power, influencing the prices paid to producers, which would not be indicative of perfect competition. This approach makes an unwarranted generalization and ignores the specific dynamics of the Alabama poultry supply chain. A further incorrect approach would be to conclude that any market with price fluctuations is not perfectly competitive. In fact, price fluctuations are expected in a perfectly competitive market as supply and demand shift. The key is whether individual producers can influence these price fluctuations through their own output decisions. If producers are indeed price takers, their individual actions will not significantly impact the market price, and the market will adjust to new equilibrium prices. This approach misunderstands the nature of price discovery in competitive markets. Professional reasoning. Professionals evaluating market structures under Alabama Antitrust Law should adopt a systematic, evidence-based approach. This involves 1. Identifying the relevant market. Define the geographic and product market for the goods or services in question. 2. Assessing market structure. Analyze the number and size of firms, product differentiation, barriers to entry and exit, and information availability. 3. Evaluating market conduct. Observe how firms behave within the market, particularly regarding pricing and output decisions. 4. Determining market performance. Examine the outcomes of market activity, such as prices, output levels, and efficiency. When considering perfect competition, the focus should be on whether the market conditions substantially align with its theoretical definition, allowing for minor deviations that do not fundamentally alter the competitive landscape. This analytical framework ensures that antitrust assessments are grounded in economic reality and legal principles, rather than assumptions or incomplete analyses. Question 13. Research into the practices of a dominant fertilizer supplier in Alabama has revealed that it has recently implemented a significant price reduction for its products in specific rural counties, coinciding with the entry of a new, smaller competitor. Local farmers have reported concerns that this aggressive pricing may be intended to drive the new competitor out of business, thereby allowing the dominant supplier to regain its previous pricing power. Considering the principles of Alabama antitrust law, which of the following investigative approaches best aligns with the definition and purpose of antitrust law in the state? Option A. Conduct a comprehensive investigation into the dominant supplier's pricing strategies, market share, the new competitor's viability, and the overall impact on fertilizer availability and prices for farmers in the affected Alabama counties to determine if competition is being substantially lessened or a monopoly is being created. Option B. Investigate the dominant supplier's financial health and profitability to ascertain if the price reduction is causing the company to incur losses, assuming that if the company is not losing money, the pricing is not anti-competitive. Option C. Focus solely on the dominant supplier's stated business objectives of expanding its customer base and dismiss the farmer's concerns as mere complaints from competitors unable to keep up with market dynamics. Option D. Immediately conclude that the dominant supplier's actions are a legitimate business practice aimed at increasing market share through competitive pricing, as Alabama law generally favors robust competition. The correct answer is A. Conduct a comprehensive investigation into the dominant supplier's pricing strategies, market share, the new competitor's viability, and the overall impact on fertilizer availability and prices for farmers in the affected Alabama counties to determine if competition is being substantially lessened or a monopoly is being created. Explanation. This scenario presents a professional challenge because it requires distinguishing between legitimate business competition and anti-competitive conduct that harms consumers and the Alabama economy, as defined by Alabama antitrust law. The challenge lies in interpreting the nuances of business practices and their market impact, demanding careful judgment to avoid both over-enforcement and under-enforcement of the law. The correct approach involves a thorough investigation into the alleged conduct, focusing on whether it substantially lessens competition or tends to create a monopoly in the relevant market within Alabama. This requires gathering evidence on pricing strategies, market share, barriers to entry, and the overall impact on consumers in terms of choice and price. The purpose of Alabama antitrust law is to protect competition and, by extension, consumers from anti-competitive practices. Therefore, an approach that prioritizes understanding the actual or potential harm to competition and consumers by examining the specific market dynamics and the intent and effect of the alleged actions aligns directly with the statutory goals. This includes assessing if the actions are predatory, exclusionary, or collusive in a way that violates Alabama's antitrust statutes. An incorrect approach would be to immediately assume that any aggressive pricing or market expansion by a dominant firm is illegal. This fails to recognize that market leadership can be achieved through legitimate innovation and efficiency. Such an approach would stifle healthy competition and innovation, contrary to the broader economic goals of antitrust law. Another incorrect approach would be to dismiss the complaint solely because the companies involved are large and successful. Size alone does not equate to illegality under Alabama antitrust law. The focus must be on the conduct and its effect on competition, not merely the size of the entities involved. Ignoring potential anti-competitive conduct based on the perceived legitimacy of market success would be a failure to uphold the law's protective purpose. A further incorrect approach would be to focus only on the stated intentions of the businesses, without examining the actual or probable consequences of their actions on the Alabama market. While intent can be a factor, the ultimate determination of a violation rests on whether the conduct has had, or is likely to have, a substantial anti-competitive effect. Overlooking the market impact in favor of stated business goals would undermine the law's objective of safeguarding consumer welfare and market fairness. Professionals should employ a decision-making framework that begins with a clear understanding of the relevant Alabama antitrust law provisions. This involves identifying the alleged conduct, defining the relevant product and geographic markets within Alabama, and then meticulously analyzing the conduct's impact on competition within those markets. Evidence gathering should be comprehensive, considering both direct and circumstantial evidence of anti-competitive intent and effect. The analysis should be objective, grounded in economic principles and legal precedent specific to Alabama, and always prioritize the protection of competition and consumers. Question 14. System analysis indicates that a large technology company operating in Alabama has introduced a new software feature that significantly enhances user experience, but also creates a proprietary ecosystem, making it difficult for competing software to integrate. While the company claims this is simply product innovation to meet consumer demand in Alabama, some smaller Alabama-based software developers argue this move is designed to stifle competition and create a de facto monopoly. Based on Alabama antitrust law, what is the most appropriate course of action for regulators to determine if this conduct is anti-competitive? Option A. Focus solely on the technology company's substantial profits and market share in Alabama, assuming that such success must be due to anti-competitive practices. Option B. Immediately issue a cease and desist order against the technology company, citing the introduction of proprietary features as inherently anti-competitive under Alabama antitrust law. Option C. Rely on statements from the smaller Alabama-based software developers and public outcry to conclude that the technology company's actions are a violation of Alabama antitrust law. Option D. Conduct a comprehensive investigation into the software features' impact on market competition, consumer choice, and barriers to entry within Alabama, gathering evidence on pricing, integration challenges, and the availability of viable alternatives for Alabama consumers. The correct answer is D. Conduct a comprehensive investigation into the software features' impact on market competition, consumer choice, and barriers to entry within Alabama, gathering evidence on pricing, integration challenges, and the availability of viable alternatives for Alabama consumers. Explanation. System analysis indicates that this scenario presents a professionally challenging situation due to the subtle nature of monopolistic competition and its potential to harm consumers and stifle innovation within Alabama's market. The challenge lies in distinguishing between legitimate competitive differentiation and anti-competitive practices that exploit market power. Careful judgment is required to assess whether a firm's actions, while appearing to be product differentiation, are in fact designed to create artificial barriers to entry or engage in predatory pricing, thereby harming competition in Alabama. The best professional approach involves a thorough investigation into the specific market dynamics and the firm's conduct, focusing on the impact on competition and consumer welfare within Alabama, as guided by the Alabama antitrust law. This approach requires gathering evidence on pricing strategies, product differentiation claims, market share trends, and barriers to entry. The justification for this approach lies in its direct alignment with the core principles of antitrust law, which aim to protect the competitive process. By examining the actual effects of the firm's actions on the Alabama market, regulators can determine if the conduct violates the spirit and letter of the law, which seeks to prevent monopolistic practices and ensure fair competition for the benefit of Alabama consumers. An incorrect approach would be to assume that any form of product differentiation automatically constitutes a violation of Alabama antitrust law. This is flawed because product differentiation is a legitimate and often beneficial aspect of a competitive market, allowing firms to cater to diverse consumer preferences. Condemning it without examining its actual impact on competition in Alabama would stifle innovation and consumer choice. Another incorrect approach would be to focus solely on the size or profitability of the firm without assessing its market power or the specific conduct that might be anti-competitive. Profitability alone does not indicate a violation of antitrust law. It is the abuse of market power that is prohibited. Without this crucial link, such an assessment would be incomplete and potentially lead to erroneous conclusions regarding Alabama's competitive landscape. Finally, an incorrect approach would be to rely on anecdotal evidence or public perception without conducting a rigorous, evidence-based investigation into the firm's practices and their impact on the Alabama market. This lacks the necessary objectivity and legal grounding to make an informed decision under Alabama antitrust law. The professional reasoning process for similar situations should involve a systematic evaluation of market structure, firm conduct, and market performance. Professionals must first understand the relevant market in Alabama, identify the specific conduct in question, and then analyze its actual or potential impact on competition and consumer welfare. This requires a deep understanding of antitrust principles and the ability to apply them to the specific facts of a case, always with a focus on the jurisdiction's specific legal framework. Question 15. Governance review demonstrates that Dixie Cement, a major supplier of cement in Alabama, is under investigation for potentially possessing and abusing market power. The Alabama Attorney General's office is seeking to determine if Dixie Cement can profitably raise prices above competitive levels for a sustained period. Which of the following analytical approaches best aligns with the principles of Alabama antitrust law for assessing market power? Option A. An investigation that relies heavily on complaints from a limited number of former customers who claim they were forced to pay higher prices without conducting broader economic analysis. Option B. An evaluation centered on Dixie Cement's recent profit margins and overall financial performance, assuming that high profitability is the definitive indicator of market control. Option C. An assessment primarily focused on Dixie Cement's historical market share percentages over the past decade, assuming that a high market share directly equates to significant market power. Option D. A comprehensive market analysis that defines the relevant product in geographic markets, examines barriers to entry, assesses the degree of product substitutability, and evaluates buyer power, in addition to considering market share. Correct answer is D. A comprehensive market analysis that defines the relevant product in geographic markets, examines barriers to entry, assesses the degree of product substitutability, and evaluates buyer power, in addition to considering market share. Explanation. Governance review demonstrates that a dominant cement manufacturer in Alabama, Dixie Cement, has been accused of engaging in practices that may stifle competition. The Alabama Attorney General's office is investigating whether Dixie Cement possesses undue market power and has used it to the detriment of smaller competitors and consumers. This scenario is professionally challenging because assessing market power requires a nuanced understanding of economic principles and their application within the specific legal framework of Alabama antitrust law. Misjudging market power can lead to incorrect conclusions about anti-competitive conduct, potentially resulting in unwarranted enforcement actions or, conversely, a failure to protect the competitive landscape. The best approach to assessing Dixie Cement's market power involves a comprehensive analysis of the relevant product in geographic markets, considering factors beyond simple market share. This includes evaluating the ease of entry for new competitors, the substitutability of products from other industries, and the ability of buyers to switch suppliers. Alabama antitrust law, like federal antitrust law, focuses on whether a firm has the ability to profitably raise prices above competitive levels for a sustained period. Therefore, a thorough examination of these economic indicators, interpreted through the lens of Alabama's specific statutory provisions and case law, is crucial. This approach directly addresses the core inquiry of market power as defined by antitrust principles, aiming to identify whether Dixie Cement can act independently of competitive forces. An approach that solely relies on Dixie Cement's historical market share, without considering other critical factors, is professionally unacceptable. Market share alone is a snapshot and does not necessarily reflect a firm's ability to control prices or exclude competition, especially if barriers to entry are low or if there are readily available substitutes. This failure to conduct a holistic market analysis ignores the dynamic nature of competition and the economic realities that define market power under Alabama antitrust law. Another professionally unacceptable approach would be to focus exclusively on the profitability of Dixie Cement. While profitability can be an outcome of market power, it is not a direct measure of it. A highly profitable firm might be so due to superior efficiency, innovation, or lower costs, rather than due to anti-competitive market control. Relying solely on profitability risks misattributing success to market power when it may stem from legitimate business advantages, thereby misinterpreting the intent and scope of Alabama antitrust law. Finally, an approach that prioritizes anecdotal evidence from a few disgruntled customers without rigorous economic analysis is also flawed. While customer complaints can be a starting point for investigation, they do not constitute sufficient evidence of market power. Comprehensive assessment requires objective economic data and analysis to determine if the alleged harm is widespread and attributable to anti-competitive conduct, rather than isolated incidents or specific customer grievances. The professional decision-making process for similar situations should involve a multifaceted approach. First, clearly define the relevant product and geographic markets. Second, gather and analyze all relevant economic data, including market shares, entry barriers, buyer power, and product substitutability. Third, interpret this data within the specific legal framework of Alabama antitrust law, considering relevant statutes, regulations, and judicial precedent. Fourth, consult with economic experts to ensure the analysis is robust and defensible. Finally, base conclusions and recommendations on the totality of the evidence, rather than isolated factors. Question 16. Governance review demonstrates that a dominant retail chain in Alabama has implemented a new pricing strategy that significantly undercuts its smaller, independent competitors, leading to several of them closing their doors. A complaint is filed with the Alabama Attorney General's office alleging a violation of the Alabama Competition Act. What is the most appropriate initial course of action for the Attorney General's office? Option A. Advise the smaller competitors to merge to create a stronger entity capable of competing with the dominant chain. Option B. Initiate a comprehensive investigation into the pricing strategy, examining market share, the intent behind the pricing, the duration and impact of the strategy on the relevant retail market in Alabama, and its effect on consumer choice and prices. Option C. Issue a public statement condemning the dominant retail chain's actions and urging consumers to boycott their stores. Option D. Immediately file a lawsuit against the dominant retail chain, seeking injunctive relief and damages based on the competitor's complaint. The correct answer is B. Initiate a comprehensive investigation into the pricing strategy, examining market share, the intent behind the pricing, the duration and impact of the strategy on the relevant retail market in Alabama, and its effect on consumer choice and prices. Explanation. This scenario is professionally challenging because it requires a nuanced understanding of Alabama antitrust law, specifically the Alabama Competition Act, to discern between legitimate business practices and potential violations. The challenge lies in identifying when aggressive competition crosses the line into anti-competitive conduct that harms consumers or other businesses. Careful judgment is required to avoid both overzealous enforcement that stifles innovation and under-enforcement that allows market power to be abused. The correct approach involves a thorough investigation into the alleged conduct, focusing on whether the actions of the dominant firm have had a demonstrable anti-competitive effect on the relevant market in Alabama. This includes analyzing the intent behind the actions, the market power of the firm, the duration and intensity of the conduct, and its impact on competition and consumers. Specifically, under the Alabama Competition Act, proving a violation often requires demonstrating that the conduct substantially lessens competition or tends to create a monopoly in any line of commerce in Alabama. This approach is correct because it aligns with the statutory purpose of the Act, which is to promote competition and protect consumers from monopolistic practices. It requires evidence-based analysis rather than mere suspicion. An incorrect approach would be to immediately pursue legal action based solely on the complaint from a competitor without conducting an independent, objective investigation. This fails to acknowledge that competitor complaints can sometimes be motivated by a desire to stifle legitimate competition rather than genuine harm to the market. Such an approach risks baseless litigation and could chill legitimate business activities. Another incorrect approach would be to assume that a firm's dominant market position automatically equates to illegal anti-competitive behavior. While market dominance is a factor, it is not in itself a violation of antitrust law. The law prohibits anti-competitive conduct, not simply being large or successful. This approach ignores the critical element of proving actual or probable harm to competition. Finally, an approach that focuses only on the financial impact on the complaining competitor, without assessing the broader impact on the relevant market and consumers in Alabama, is also flawed. Antitrust law is concerned with the health of the market as a whole, not just the fortunes of individual competitors. Professionals should employ a decision-making framework that begins with a neutral and objective assessment of all available information. This involves gathering evidence, understanding the relevant market dynamics in Alabama, and applying the principles of the Alabama Competition Act. If initial findings suggest a potential violation, a deeper investigation should be initiated, considering the intent, conduct, and effect of the alleged anti-competitive actions. Legal counsel should be consulted to ensure compliance with all procedural and substantive requirements of Alabama antitrust law. Question 17. Operational review demonstrates that Southern Steelworks, Inc., a major steel producer in Alabama, is proposing to acquire Gulf Coast Metals, LLC, a smaller but innovative Alabama-based competitor specializing in specialized alloy production. Southern Steelworks, Inc., argues that the acquisition will lead to significant cost synergies, allowing for greater investment in research and development of new steel products, which will ultimately benefit Alabama consumers through improved product quality and lower prices. However, some industry analysts express concern that the combined entity could control a substantial portion of the raw material supply chain for specialized alloys within Alabama, potentially making it prohibitively expensive for new entrants to establish a competitive presence or for existing smaller producers to scale their operations. Considering Alabama antitrust law, what is the most prudent course of action for an antitrust compliance officer advising Southern Steelworks, Inc. on this proposed acquisition? Option A. Proceed with the acquisition, relying solely on Southern Steelworks, Inc.'s assurances that the primary goal is to achieve operational efficiencies and invest in R&D, as these stated intentions are generally viewed favorably under antitrust law. Option B. Focus the analysis primarily on the current market share of Southern Steelworks, Inc. and Gulf Coast Metals, LLC, and if their combined share remains below a certain threshold, conclude that the acquisition is unlikely to raise significant antitrust concerns regarding barriers to entry. Option C. Conduct a comprehensive analysis of the proposed acquisition's impact on barriers to entry in the Alabama specialized alloy market, specifically assessing whether the control over raw material supply would create unjustified impediments to new entry or expansion, and advise on potential remedies if significant anti-competitive barriers are identified. Option D. Advise Southern Steelworks, Inc. that any increase in barriers to entry is an acceptable consequence of achieving economies of scale and fostering innovation, as long as the company commits to future investment in new product development within Alabama. The correct answer is C. Conduct a comprehensive analysis of the proposed acquisition's impact on barriers to entry in the Alabama specialized alloy market, specifically assessing whether the control over raw material supply would create unjustified impediments to new entry or expansion, and advise on potential remedies if significant anti-competitive barriers are identified. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a nuanced understanding of Alabama antitrust law, specifically concerning barriers to entry in the context of a proposed acquisition. The challenge lies in distinguishing between legitimate business efficiencies that might incidentally raise barriers and anti-competitive conduct designed to unlawfully exclude rivals. Careful judgment is required to assess whether the proposed integration genuinely enhances competition through innovation and efficiency, or if it is a strategic move to entrench market power by making it prohibitively difficult for new or existing competitors to enter or expand. Correct approach analysis. The best professional practice involves a thorough analysis of the proposed acquisition's impact on barriers to entry, focusing on whether the integration would create or exacerbate barriers that are not justified by pro-competitive benefits. This approach requires evaluating factors such as increased economies of scale, control over essential inputs or distribution channels, intellectual property rights, and regulatory hurdles. If the analysis concludes that the acquisition would create significant, unjustified barriers that are likely to harm competition in Alabama, then the appropriate action is to advise against the transaction or recommend significant divestitures to mitigate these effects. This aligns with the principles of Alabama antitrust law, which aims to prevent mergers that substantially lessen competition or tend to create a monopoly by examining their impact on market structure and the ease of entry for potential competitors. Incorrect approaches analysis. One incorrect approach would be to dismiss concerns about barriers to entry solely because the acquiring firm claims the primary motivation is to achieve operational efficiencies and cost savings. While efficiencies are a relevant consideration, they do not automatically negate the potential for anti-competitive effects. Alabama antitrust law requires a balancing of pro-competitive justifications against anti-competitive harms, and simply asserting efficiency does not absolve the parties from demonstrating that these efficiencies outweigh any resulting increase in barriers to entry that harms competition. Another incorrect approach would be to focus exclusively on the current market share of the merging entities, without adequately assessing how the transaction might alter the future competitive landscape by raising barriers to entry. Market share alone is a snapshot. The law is concerned with the dynamic effects of a merger, including its potential to deter new entrants or limit the expansion of existing smaller competitors by making it more difficult and costly for them to compete. A further incorrect approach would be to assume that any increase in barriers to entry is acceptable as long as the acquiring firm intends to invest in innovation. While innovation is a positive outcome, law is concerned with the asterisk means asterisk by which market power is maintained or enhanced. If the increased barriers are not a natural consequence of superior innovation or efficiency, but rather a result of strategic actions that foreclose competition, then such an increase is problematic under Alabama antitrust law. Professional reasoning. Professionals should adopt a structured approach when evaluating potential mergers and their impact on barriers to entry. This involves 1. Defining the relevant market in Alabama. 2. Assessing the current level of barriers to entry in that market. 3. Analyzing how the proposed transaction would specifically alter those barriers, e.g., through economies of scale, control of inputs, network effects, intellectual property, or regulatory capture. 4. Evaluating whether any resulting increase in barriers is justified by demonstrable pro-competitive efficiencies that benefit Alabama consumers. 5. Considering the likelihood of new entry and the ability of existing smaller competitors to expand in the post-merger market. 6. Recommending actions, e.g., divestitures, behavioral remedies, to mitigate anti-competitive barriers if they are found to be significant and unjustified. Question 18. Which analytical framework would be most appropriate for a law firm in Birmingham, Alabama, to use when evaluating a proposed joint venture between two independent distributors of plumbing supplies, where the distributors claim the venture will lead to greater efficiency in logistics and purchasing, but there are concerns about potential market foreclosure in certain geographic areas of Alabama? Option A. A per se illegality analysis, assuming all joint ventures between competitors are automatically illegal. Option B. An analysis focused solely on the subjective intent of the distributors to improve efficiency without regard to market impact. Option C. An analysis that ignores the definition of the relevant market, focusing only on the number of competitors involved. Option D. The rule of reason analysis, which weighs the pro-competitive benefits against the anti-competitive harms after defining the relevant market. The correct answer is D. The rule of reason analysis, which weighs the pro-competitive benefits against the anti-competitive harms after defining the relevant market. Explanation. This scenario presents a professional challenge because it requires a nuanced understanding of Alabama antitrust law to determine the appropriate framework for analyzing potential anti-competitive conduct. Misapplying the framework can lead to incorrect conclusions about the legality of business practices, potentially resulting in significant legal and financial repercussions for the involved parties and the firm. Careful judgment is required to select the analytical tool that best fits the specific facts and the nature of the alleged restraint. The most appropriate approach is to utilize the rule of reason analysis. This framework, deeply embedded in Alabama antitrust jurisprudence, is designed to assess the competitive effects of agreements or practices that are not inherently anti-competitive on their face. It involves a thorough examination of the business justifications for the restraint, the extent of market power, the nature and duration of the restraint, and its actual or probable impact on competition within the relevant market. This approach is correct because it allows for a balanced consideration of both the pro-competitive benefits and the anti-competitive harms, aligning with the objective of Alabama antitrust law to promote competition while acknowledging legitimate business efficiencies. An incorrect approach would be to automatically apply a per se rule. This rule presumes that certain agreements, such as price fixing or market allocation, are so inherently anti-competitive that they are illegal without further inquiry into their actual effects. Applying this rule to a situation that does not clearly fall into one of these per se categories would be a regulatory failure, as it would condemn potentially legitimate business conduct without proper analysis. Another incorrect approach would be to focus solely on the intent of the parties involved, without considering the actual or probable competitive effects. While intent can be a factor, Alabama antitrust law primarily focuses on the economic impact of the conduct on competition. Ignoring market realities and competitive outcomes in favor of subjective intent would be an ethical and regulatory failure, as it would not adequately protect the competitive process. Finally, an incorrect approach would be to analyze the situation without defining the relevant market. Market definition is a crucial first step in any antitrust analysis, as it establishes the competitive arena in which the alleged restraint operates. Failing to define the relevant market would render any subsequent analysis of competitive effects speculative and unreliable, representing a significant failure in applying the established analytical framework. Professionals should approach such situations by first identifying the nature of the alleged restraint. If the conduct appears to be one of the well-established per se violations, that framework might be applicable. However, for most business agreements and practices, the rule of reason is the default and most appropriate analytical tool. This requires a systematic evaluation of market power, the nature and scope of the restraint, and its impact on competition, always guided by the principles of Alabama antitrust law. Question 19. Investigation of alleged price fixing and market allocation among lumber mill owners in Alabama during the 1890s reveals that these mill owners met regularly to agree on the minimum price for lumber sold within the state and to divide territories where they would sell their products. Considering the historical context of Alabama antitrust law during that era, which of the following assessments is most accurate? Option A. The primary focus of Alabama antitrust law in the 1890 was on preventing monopolistic control of raw materials, and agreements among sellers of finished goods like lumber were generally not considered within the purview of the state's antitrust statutes. Option B. The economic impact of the lumber mill owners' agreements, leading to higher prices for consumers, would have been sufficient to establish a violation of Alabama antitrust law in the 1890, regardless of the specific judicial interpretations of the statutes at that time. Option C. The agreements among the lumber mill owners to fix prices and allocate territories would have been considered a per se violation of Alabama antitrust law in the 1890s, similar to how such conduct is treated under contemporary antitrust statutes. Option D. The actions of the lumber mill owners, while appearing anti-competitive by modern standards, may not have constituted a violation of Alabama antitrust law as interpreted at the time, which often required a more direct and substantial showing of intent to monopolize or a significant restraint on trade than might be evident from the described agreements alone. The correct answer is D. The actions of the lumber mill owners, while appearing anti-competitive by modern standards, may not have constituted a violation of Alabama antitrust law as interpreted at the time, which often required a more direct and substantial showing of intent to monopolize or a significant restraint on trade than might be evident from the described agreements alone. Explanation. This scenario is professionally challenging because it requires understanding the historical evolution of antitrust law in Alabama and how early interpretations might differ from modern applications, particularly concerning the concept of restraint of trade. The challenge lies in distinguishing between actions that were historically permissible or viewed differently under older legal standards and those that would unequivocally violate current Alabama antitrust statutes. Careful judgment is required to apply the correct legal framework to the historical facts presented. The correct approach involves recognizing that the Alabama Supreme Court's interpretation of the state's antitrust laws, particularly in early cases, often focused on a narrower definition of restraint of trade than what is understood today. This approach correctly identifies that while the actions of the lumber mill owners might appear anti-competitive by modern standards, they could have been viewed as legitimate business practices or not falling within the scope of the then-existing Alabama antitrust statutes, which were influenced by early interpretations of federal antitrust law. The justification for this approach lies in the principle of applying the law as it existed at the time of the alleged conduct, acknowledging that legal doctrines evolve. Alabama's antitrust laws, like many state statutes, have been shaped by judicial interpretation over time, and early decisions may have adopted a more lenient stance on certain business arrangements. An incorrect approach would be to immediately apply contemporary understandings of antitrust law, such as per se violations or broad interpretations of market power, to the historical facts. This fails to acknowledge the historical context and the specific legal interpretations prevalent in Alabama during the late 19th or early 20th century. Such an approach would be a regulatory failure because it misapplies the relevant legal standard, leading to an inaccurate assessment of whether a violation occurred under the laws in force at that time. Another incorrect approach would be to assume that any agreement between competitors to fix prices or allocate markets, regardless of the historical period, automatically constitutes a violation of Alabama antitrust law. This is often true under modern law. Historical interpretations might have required a showing of intent to monopolize or a more direct and substantial restraint on trade than what was readily apparent or legally recognized at the time. This approach represents an ethical failure by not adhering to the principle of applying historical laws to historical events. A further incorrect approach would be to focus solely on the economic impact of the lumber mill owner's actions, without considering the specific language and judicial interpretation of Alabama's antitrust statutes during the relevant historical period. While economic effects are crucial in modern antitrust analysis, historical legal frameworks might have had different evidentiary requirements or conceptual understandings of what constituted an illegal restraint of trade. This approach risks anachronism, judging past actions by present-day standards. A professional reasoning process for similar situations should involve a thorough historical legal research into the specific antitrust statutes of the relevant state, in this case, Alabama, and crucially, the case law interpreting those statutes during the period in question. Professionals must resist the temptation to apply current legal understanding without first establishing the historical legal landscape. This involves examining early judicial decisions, legislative intent at the time of enactment, and any amendments or significant legal developments that occurred. Understanding the evolution of legal concepts like restraint of trade and monopoly within the specific jurisdiction is paramount to accurate legal analysis. Question 20. A group of competing plumbing supply companies in Birmingham, Alabama, are suspected of entering into an agreement to set minimum prices for residential water heaters. An investigation reveals that following this agreement, the average price of a standard water heater sold by these companies increased from $500 to $550 over a 6-month period. The total annual sales of water heaters by these companies in Birmingham amount to $10,000,000. If the court finds that the agreement to fix prices is a per se violation of the Alabama Antitrust Act, and that the $50 price increase was solely attributable to this illegal agreement, what is the maximum potential damages a plaintiff could seek under the Act? Option A, $3,000,000. Option B, $1,500,000. Option C, $550,000. Option D, $500,000. The correct answer is A, $3,000,000. Explanation: scenario analysis. This scenario presents a professional challenge due to the potential for a business to engage in price fixing, a per se violation under Alabama antitrust law. The core difficulty lies in distinguishing between legitimate, independent business decisions and coordinated actions designed to suppress competition. The calculation of potential damages requires a precise understanding of market dynamics and the application of statutory remedies, demanding careful judgment to avoid both underestimation and overestimation of harm. Correct approach analysis. The best professional practice involves a thorough analysis of the alleged conduct against the per se rule established by the Alabama Antitrust Act. This approach correctly identifies that price fixing, if proven, is inherently anti-competitive and does not require a complex rule of reason analysis to demonstrate illegality. The calculation of damages should be based on a reasonable estimation of the difference between the prices charged under the alleged conspiracy and the prices that would have prevailed in a competitive market. This estimation can be achieved by analyzing historical pricing data, market share shifts, and expert economic testimony to quantify the overcharge. The Alabama Antitrust Act allows for treble damages, meaning the actual damages suffered are multiplied by 3. Therefore, the calculation should focus on determining the actual economic harm first. For instance, if a market study estimates that consumers paid an average overcharge of 10% on a product with annual sales of $10,000,000 due to the conspiracy, the actual damages would be $1,000,000. The potential recovery under the Act would then be /3 / times $1,000,000 $000 equals $3, $000,000. This method directly applies the statutory framework and aims to restore the injured parties to the economic position they would have occupied absent the illegal conduct. Incorrect approaches analysis. One incorrect approach would be to solely focus on whether the businesses achieved a significant profit increase. While profit is a consequence of business operations, the illegality of price fixing under Alabama law hinges on the agreement to fix prices, not solely on the resulting profit margin. The Act prohibits the agreement itself, regardless of whether it leads to exorbitant profits or merely maintains existing ones. This approach fails to address the core violation of suppressing competition and artificially inflating prices. Another incorrect approach would be to calculate damages based on a percentage of the defendant's total revenue, without first establishing the direct impact of the price-fixing conspiracy on the prices paid by consumers or purchasers. Alabama antitrust law focuses on the harm caused by anti-competitive conduct. Damages should reflect the economic injury directly attributable to the illegal agreement, not a broad calculation based on overall business volume that may include revenue from non-affected products or services. A further incorrect approach would be to assume that any price increase automatically constitutes a violation, and to calculate damages based on the entire price increase observed. Alabama antitrust law, while employing a per se rule for price fixing, still requires proof that an agreement to fix prices actually occurred, and that this agreement caused the price increase. A simple observation of rising prices without evidence of a conspiracy is insufficient. Damages should be calculated based on the portion of the price increase demonstrably caused by the illegal agreement, not the entirety of any observed price hike. Professional reasoning. Professionals facing such a situation should first identify the alleged conduct and determine if it falls under a per se violation of the Alabama Antitrust Act, such as price fixing. If it does, the focus shifts to proving the existence of the agreement and quantifying the economic harm caused by that agreement. This involves gathering evidence of the conspiracy and employing economic analysis to estimate the difference between actual prices and competitive prices. The statutory treble damages provision should then be applied to the calculated actual damages. Professionals must avoid focusing on secondary consequences like profit margins or unrelated business metrics, and instead concentrate on the direct causal link between the illegal agreement and the economic injury to the market.